My Lord, I would like to associate myself. My name is Jackie Amsugut. I would like to associate myself with my colleague's submissions, but I just want to emphasize that as has been rightly submitted by my former teacher, my Lord, Council Kalibala, that yes, one of the orders, one of the conditions has been fulfilled, and that is the production of the applicant. Now, the other issue would be the lawfulness, or whether or not he is in illegal or legal detention. My Lord, I want to emphasize that we should not read into the judgment of the Supreme Court what it did not provide. This was a decision of the Supreme Court, not sitting as an ordinary court, but as a constitutional court. And my Lord, as the highest court of the land. Now, my Lord, as officers of the court, we need to respect court orders. And for the applicants to come to this court and read into the court's decision that the warrants that were given by the court-martial have been invalidated is a very serious misconception, my Lord. Our submission, my Lord, is that the applicants are in lawful custody. And why am I saying that? I would like to make reliance on an authority of R versus Governor of Brixton Prison. And in fact, my Lord, I am trying to justify that we are holding him or holding the applicants in a lawful way, or we are having them in lawful custody, supporting what my teacher has said, that we should justify that we are holding him in lawful custody. And in this decision, my Lord, it's called R versus Governor of Brixton Prison ex parte Ama. My Lord, the House of Lords was examining whether a detainee held under extradition proceedings could be released via habeas corpus, despite procedural irregularities. The court held that even where there are procedural errors, detention remains lawful if there exists a valid substantive basis for the person's confinement. The emphasis, my Lord, is if there exists a valid substantive basis for the person's confinement. My Lord, this is the valid. Yes, my Lord, we'll supply it to the court. Now, my Lord, in this case, Dr. Kiza Besigye, for the applicants here, were arrested and charged with various criminal offenses, including treason, my Lord, which justifies their pre-trial detention under Ugandan law. The fact that this case was initially handled by the court-martial does not negate or does not invalidate that we had valid reasons, my Lord, to detain them. And my Lord, the Supreme Court, well aware of this, simply said, transfer them to the civil court. Our submission, my Lord, is any argument about a warrant being not valid can only be made after the process of transfer has been completed, and this will happen before the criminal court, which is going to handle his matter. My Lord, it is very misconceiving and misleading for this court handling a matter for habeas corpus to go into questioning the validity of the warrant, which is the basis for which the applicants are saying we are holding him illegally. My Lord, that is not the purpose for habeas corpus. We are praying, my Lord, that you be persuaded by this decision. And my Lord, we have highlighted the relevant facts, and you will notice that the court says, the court actually says that you should not question, that the question then arises, what should be the proper approach by the court in determining any such inquiry it may make. Of course, the authority on which the Galoa holds the applicant is the authority of the court. The court-martial was a court at that time. Can only, and it is still a court, can only be to see whether the court, this is what this court says, can only be to see whether the court had facts before them entitling them to issue the authority, the warrant. This is what we are telling you, my Lord, that we had valid reasons to detain the applicant. So to argue right now that the warrant is invalid is not proper before you, my Lord. And on that basis, my Lord, we pray that this application is dismissed for being premature. We have clearly stated to you through the affidavit of Judge Kalemera the processes that the Attorney General has taken in compliance with the orders of the Supreme Court, not outside the orders of the Supreme Court. My Lord, we pray that you are persuaded by our submissions and dismiss this application with justice.